So the Supreme Court issued a decision denying emergency review in a case that was seeking an immediate block of New York's controversial rifle and shotgun permit requirements. That denial caused a dismissal of the challenge, and now the lower court is looking to do the same. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. They're pro 2A, pro freedom. And right now, if you're looking, on your New Year's resolution to get healthier, to work out more, I cannot recommend 1st Phorm enough. They have a ton of supplements that can help you along with your journey. And right now, if you order using my link down below and you order something $50 or more, you will get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, we're going to be discussing an important case which deals with a rifle and shotgun permit system and a current Supreme Court emergency denial that as a result got this case thrown out by the 2nd Circuit Court of Appeals. This case challenges New York City's permit requirements that must be met to possess a rifle and shotgun within the city. The case we're going to be talking about in this video is called Schrower versus the City of New York. Now, under this permit, the police department gets pure discretion to determine who has good moral character and essentially who gets a permit and who does not. The emergency application in this case recently went to the Supreme Court, but the case was then denied emergency review. The Supreme Court denied emergency review, and at that time, they essentially wanted the 2nd Circuit to rule on this case. After that denial, the 2nd Circuit was free to issue their decision. However, the 2nd Circuit then took the radical approach. They decided instead of ruling on the merits of the case, they ruled to instead moot the entire case and dismiss the entire case and throw it all out. This has now set up this case to potentially be completely thrown out by the lower court as well, and could also set up a new petition to the Supreme Court. The plaintiffs argue that under Bruin, the Supreme Court struck down a very similar application process that was also purely discretionary. The Supreme Court found in Bruin that there was no historical support at all within the history and tradition of the United States for purely discretionary CCW permits, and now the plaintiffs say in the same way, there is no historical support for a may issue firearms possession permit. This case was brought by a plaintiff, Joseph Schrower, who challenges the constitutionality of the New York City discretionary licensing scheme, and he wants to essentially enjoin permanently that permit that's in place. Now, on review, the district court granted a permanent injunction against a provision of the licensing scheme that essentially required individuals to prove that they had good moral character. That, of course, was a huge win, but the City of New York did not like that. They didn't want that to stand, so they appealed up to the 2nd Circuit Court of Appeals. New York also sought a stay to be put in place on that permanent injunction of the good moral character determination, and essentially on review, the 2nd Circuit granted that temporary stay. At that point, an emergency application was then filed to the Supreme Court to remove that stay, but ultimately the Supreme Court decided they did not want to get involved. But that denial of the application then had huge ramifications for this case. As a result of that denial, the case moved forward at the 2nd Circuit level, and the 2nd Circuit decided to not review the merits of this case, but instead strike down the entire lawsuit. At the oral arguments in front of the 2nd Circuit, the City of New York then began to argue that the entire lawsuit should in fact be thrown out as moot, because they argued Mr. Schrower had received a permit since filing the lawsuit, and since the City of New York gave him that permit, they argued that the relief he wanted was now met and the case did not need to move forward and should just simply be thrown out. When reviewing the hearing, I told you guys that I predicted the 2nd Circuit would actually take the easy out, find the issue was now moot, and avoid ruling on the constitutional merits of the case. And that's exactly what they did. In their decision in the order of the 2nd Circuit, they stated that we now hold that because Schrower has been granted the very relief he sought, the case before us is moot, and we lack jurisdiction to hear the merits. They went on to argue that there is no indication that the city granted Schrower's rifle and shotgun permit to intentionally moot this case, or even that its action was related to this lawsuit. Now, there are two main considerations to essentially override or rebut mootness arguments like this one that was brought. One of those being that the party tried to moot the case intentionally, and the second that even if the issue was moot, the injury is likely to recur. Schrower argued not only did the City of New York intentionally grant his permit suddenly in 2024 to moot this entire lawsuit, but also that the city still has power to revoke or deny his renewal of the permit once the permit is up in 2027. On both issues, the Second Circuit deferred to the city's claims that they did not grant the application because of this lawsuit. They also claimed they have no intent to revoke his permit or deny the renewal after the case is now mooted. And based on that, the Second Circuit threw the entire case out. However, the plaintiffs did not give up after that decision mooting the case. The plaintiffs then sought en banc panel review in the Second Circuit. However, the en banc panel in the Second Circuit quickly denied the request for a rehearing en banc. Now, interestingly, the Second Circuit decision to moot the entire case is now putting the lower court and the review of the lower court kind of in a bind. The district court in this case recently held a status conference for this case and then dismissed the City of New York's original request for a motion to dismiss the case. But now a new motion to dismiss is being requested in light of what the Second Circuit said, that the case is now moot. Now, the plaintiff here, Joseph Srouwer, recently filed the brief opposing this new motion to dismiss, arguing that this case is not moot. In the brief, he argues that the complaint did not seek an order directing the police commissioner to issue any license to plaintiff. So the city's voluntary issuance of a license to the plaintiff provided him with none of the relief sought in his complaint. The city's voluntary cessation of its enforcement of the challenge rules does not automatically render this case moot. While the Second Circuit held that the issuance of a rifle and shotgun license mooted plaintiffs' claims for injunctive relief, it was based on the court's assumption that the renewal of the rifle and shotgun license is automatic under the New York City code there that is being challenged. Handgun licenses are not automatically renewed. Every handgun license in New York City expires 3 years after its issuance. Plaintiff's handgun license will expire by operation of law in March of 2027. So Srouwer, in his opposition to the motion to dismiss, argues that the Second Circuit used incorrect assumptions on how the permits work to essentially find that this case is now moot. He also argues that the issuance of the license was not at all the type of relief that he was actually seeking. Instead, it was that he wanted the court here to find that this entire permit scheme and this whole good moral character determination is in fact unconstitutional under the Second Amendment and under the Bruin analysis. Because of that, it doesn't matter whether the city actually granted him a license or not. The relief he sought was for the law to be struck down and for there to be a permanent injunction on the law. Based on that, Srouwer argues that the Second Circuit really sidestepped the true relief that he was asking for in his lawsuit. What he really wanted was the enforcement of the law to be banned permanently and for there to be a permanent injunction. That was the relief he never got. So now this issue is back in the hands of the lower court, and there's a big battle about whether or not this lawsuit is actually moot. The big question is, did he get the relief that he was requesting? The Second Circuit said yes, he got that relief because he got a permit, but the plaintiff here, Joseph Srouwer, saying, no, I didn't actually want a permit. I wanted the entire scheme to be found unconstitutional and for me to be subject to the enforcement of this law. This also sets up a very interesting question and potential battle where if the lower court moots this case, this then could make its way back to the Supreme Court for the Supreme Court to once again have to address this issue. The Supreme Court's initial denial had ramifications where the Second Circuit decided to not actually review the merits of the case, but instead moot and throw the entire review out. And now if the lower court does the same, it could be that the Supreme Court has to get involved because the lower courts are refusing to actually address the merits of this issue. So again, a very important battle about permits when it comes to purchasing and possessing rifles and shotguns, and lower courts simply trying to avoid actually reviewing the merits of an issue. So that's what's currently going on in the New York permit scheme issue. As we get more information, I will let you guys know. If you guys like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, the station was built by armed scholars, and the station will be maintained by armed scholars.